On Thursday, the Ninth Circuit Court of Appeals, in a 2-1 decision, ruled that the federal government may not categorically deny bond hearings to migrants detained within the United States under its expanded mandatory detention policy. This decision represents a divergence from the interpretations adopted by the Fifth and Eighth Circuits, which have upheld the administration's approach, while 4 other appellate courts have similarly rejected the policy. The increasing circuit split heightens the possibility of Supreme Court intervention, as the federal government has recently petitioned the court to review the matter. The Department of Homeland Security expressed strong disagreement with the Ninth Circuit's decision and affirmed confidence in its legal stance regarding the implementation of mandatory detention. According to the department, enforcement of current policy faithfully reflects congressional intent and is essential to maintaining national security. Historically, individuals without criminal records who were apprehended within U.S. borders were generally eligible for bond hearings while their immigration cases proceeded, with mandatory detention typically applied to those detained at the border. However, guidance issued last year broadened the scope of mandatory detention to encompass individuals detained within the interior, prompting legal challenges from affected migrants seeking release from custody. Some federal judges presiding over such cases have criticized the administration for noncompliance with their orders to grant bond hearings. The government has argued that legislative amendments to immigration law in 1996 authorized the extension of mandatory detention to individuals apprehended within the United States, and contends that prior administrations failed to enforce this statutory mandate. In the majority opinion, Judge Daniel Bress, appointed by President Donald Trump, rejected this interpretation, emphasizing that the long-standing historical understanding of the relevant statutes is more persuasive despite ambiguities in the legislative text. Judge Bress was joined by Judge M. Margaret McKeown, appointed by President Bill Clinton, while Judge Carlos B., appointed by President George W. Bush, dissented, asserting that congressional intent supports the administration's position. Want to make sure you never miss our latest videos? Tap that follow button right now. If our content brought a smile to your face, made you think, or taught you something new, please like this video and share with your friends and family. Your support helps our community grow, and sharing the love only takes a second. Thank you for watching and being part of our journey.